Well, hello everyone, and welcome to Uncivil Law. For today's stream, I'm going to respond to two emails and express my continuing frustration at times that I can't always tell you what you want to hear, and when I don't, you guys are not shy about letting me know. And it's a little frustrating for me too, to be honest, because I don't quite know what to do. It's like it would be a lot easier to just pick a side and just rah for that side endlessly, right? Just pick something and just say that's the right answer every single time, regardless of the issue. But that wouldn't make me a very good legal analyst. It wouldn't make me a very good judge. A judge is supposed to be neutral and trying to apply legal principles neutrally as best they can. And so my continuing frustration is real. So I'll respond to this email, no names, of course, for respect. I'm not going to show you the email itself, but I'll read it. This email was entitled, subject line, Melanie Little versus Kurt at Uncivil Law. This is going great already. And this person writes, Kurt, I'm sadly unsubscribing from your channel due to contrasting opinions with Melanie Little concerning the orders on the motion to dismiss 03/26/2025. Okay. I hope you will watch and comment on areas of opinion that starkly contrast. Okay. I enjoy your legal analysis on court documents during the short time I've been a member of your channel. Unfortunately, the stress I feel from the injustice in this trial cannot tolerate your opinion on exculpatory evidence not being turned over to the defense as okay. She writes the word okay in quote marks, by the way. I'm not sure if I said it was okay, or that's just like paraphrasing. And your agreement with the judge. I'm referring to the judge stating the Sally Port footage was not requested, so is not required. Not okay. Best regards, name. And then P.S. I watch almost all attorneys on YouTube. I'm sure more will agree with Melanie's opinion the following days. She was the first to review this order, then I saw you were reviewing it also. Okay. And I responded to this person's email by saying in an email, I assess the law. It is what I do. In my opinion, the judge, the Karen Reed judge, Judge Bev, not those parts, just the judge, but that's what I'm talking about. The judge was correct to deny the motion to dismiss based on the legal principles that apply. Your email is an appeal to emotion, not a constructive criticism of the legal issues at play. And I find this frustrating, perhaps as much as the person who wrote to me finds what I said frustrating, because I agree that Karen Reed shouldn't be prosecuted. I agree the state's case sucks. I agree that I don't really see how they're going to be able to make proof beyond a reasonable doubt, short of the defense like falling asleep at the switch. I don't see how they're going to possibly do that. The investigation was bungled. It was crap. Evidence logs and solo cups and the police not searching the house and physics and so many problems. There are so many problems. But of course, when I'm analyzing any legal issue, including the motion to dismiss, I analyze it based on its own terms. That's what I do. And I'm like, okay, I agree or I disagree with the judge. And the fact that I think that the state can't prove their case, and the fact that I think that the first jury should have found acquittal, they should have found not guilty easily, doesn't necessarily read onto other opinions, because every case, everything is a legal issue unto itself. And I don't really know what to do beyond that, right? It's like I don't really know how to assess things other than assessing each issue as it pops up. And just because the judge is bad, or even if the judge is biased, doesn't necessarily mean they're wrong, because those are not necessarily mutually inconsistent propositions. The judge could be bad, the judge could be biased, and still be right. That is a hypothetical case that could be correct. And so I don't know what to do other than try to assess based on the things. So it's like, look, when I read the motion to dismiss for the extraordinary, fuckery right, by the defense, I'm like, okay, the judge is basically right in their legal analysis, as they quoted. This is an extraordinary thing. Even the defense calls it extraordinary. In their motion, they call it extraordinary. So it's like even the defense agrees with me to some degree, it's extraordinary. Now, they think it's extraordinary in a way that means that the trigger should be pulled. But I'm like, even they agree it's extraordinary. They think the standard's been met, and I'm like, no. And I'm like, okay, so with regards to the exculpatory evidence not being turned over, the defense is okay. Well, I'm not necessarily sure I ever said okay or not, but that it's not necessarily legally redressable. It's not necessarily something that you can do anything about. And also to the extent that there is something to do about it, this typical remedy is, of course, a new trial. That's the standard remedy. And of course, she has it now. So she doesn't have prejudice, which is part of the legal analysis relating to the motion to dismiss for the extraordinary fuckery, right? Is the nature of the prejudice. Like, can it be fixed? Can it be fixed any other way? Is there any other way to solve this problem? Can we give you more time? Can we exclude a witness? Can we prevent a question? Can we prevent evidence from coming in? Can we give you more lawyers? You know, is there any other way for us to solve this problem? Is there any other way for us to fix it? And Karen Reed's lawyers are like, nope, there's no other way to fix it. And I'm like, yeah, I don't think so. I don't think that's true. And there's just simply not sufficient evidence that's been raised at this point, to my mind. Another person might disagree, but there's not sufficient evidence at this point to, at least in my mind, to say that this is part of those cases that is so rare. And incidentally, by the way, I don't even think it was necessarily required in the Baldwin case. First of all, the Baldwin case was different for two reasons. First of all, the motion to dismiss came in the middle of the trial. So that's a different posture, right? As opposed to let's delay the trial, right? We've already sworn in the jury, so jeopardy is attached. That was the problem in the Baldwin jury. Like, we can't just give you a new trial. We're in the middle of the trial, right? You're entitled to be tried by this jury because that was the jury that was selected. There's no jury yet in Karen Reed. She's not entitled to be selected. She's not entitled to be tried by any particular jury as of yet because they haven't been selected yet. So the posture is completely different, right? Because the timing of the case. In Karen Reed, you know, hypothetically, we can just like give you more time. We could do other things. There might be other remedies. Those remedies weren't necessarily possible in Baldwin. The second reason it was different in Baldwin was because the prosecutor themselves, by the way, remember, decided to take the stand in what might be the stupidest thing I've ever seen in my life. They decided to take the stand and be like, yes, I participated with the police. I was there. I made the decision myself as part and concert with them. I made the decision to direct the evidence to not be filed in the Baldwin case and be filed in some sort of other case. I personally directed this decision myself, purposefully, to put it in the file that Baldwin would not get access to. That was me. I did those things, right? And I'm like, oh, okay, that's pretty different, right? That shows a lot of intentionality and purpose, and that shows a lot of things that aren't necessarily present in this case. You might believe those things are true in the Reed case, but there's not really great evidence of it, like there was in Baldwin, where the prosecutor's just like, yes, it was me. I did the things. Let me tell you about how I did the things. Ha 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 ha. And even still, with both those factors in play, I still don't think it was necessary for the Baldwin judge to necessarily dismiss. Even the judge themselves, while they were dismissing it, said, this is extraordinary. Basically, in so many words, said, I really probably shouldn't be doing this, but let me go through the analysis and tell you why I think it's triggered. And basically, at every step said, you know, extraordinary, really shouldn't do this. This is something you don't ever do. It's the nuke option. You don't push the nuke button, right? So it's something you never do. So, like, if the judge had said, no, I'm not going to dismiss this Baldwin thing because I can figure out some other way to solve the problem. I don't know necessarily what that would be, but if they could have figured something else out, a cautionary instruction, you know, recalling a witness, more cross-examination, whatever, like bringing this information in front of the jury. I don't know what that remedy would necessarily be. But even in Baldwin, I didn't think it was required because the standards are so like shoot the moon that basically you don't pull this trigger unless you really have to. So like even in Baldwin, I didn't think it was required. And Baldwin's facts, because of the posture, it was happening in the middle of the trial. The posture made a difference. And because of the prosecutor themselves saying, yes, it was me. Look at thee with the curly mustache and twirling my mustache. Look at me. Right? Because of the posture and because of the factual posture, it was a much easier decision to justify and still wasn't required, in my opinion. But, and so it's just like, okay, yeah. So I just am looking at this motion to dismiss and I'm like, yeah, I don't think it's true. I don't think that it's required. With respect to the exculpatory evidence not being turned over, well, it wasn't in the initial request by the defense, the information she wanted. She wanted the Sallyport video. What she asked for was information relating to evidence that was found at the crime scene, which the Sallyport is not. And so she didn't initially ask for it. And also, it's not necessarily clear that it's obviously exculpatory in a way that would necessarily trigger Brady, right? If I put myself, in the mindset of a good faith prosecutor, right? And we just say, what would the good faith prosecutor do? Like, would the good faith prosecutor necessarily know that this Sallyport video is exculpatory to Karen Read? And the answer to that question is not necessarily, because it doesn't seem to have any immediate connection to the crime, right? There's nothing about the Sallyport video that seems to have any immediate connection. Now, of course, once the defense points out, like, oh, we want to see the condition of the car or whatever, once they make that request, it's like, oh, okay, now I sort of understand it. But it wouldn't necessarily occur to me in the first instance, right? As part of my affirmative duties as the prosecutor. It wouldn't necessarily trigger in my head being like, oh, this is so obviously exculpatory because it so obviously relates to one of these things. It wouldn't necessarily cross my head. So it's like, even the good faith prosecutor, I think, could say that, I just didn't know to turn it over. You didn't request it. It wasn't in the judge's order. It wasn't on its face exculpatory in a way that would, seem to automatically trigger Brady, notwithstanding what the defense has to say to the contrary. Now, of course, it may be exculpatory because it goes to the condition of the car. But again, it's not something that would necessarily trigger my mind. But, maybe that's just me. Maybe it's because I'm not a prosecutor. Maybe it would trigger me in a different setting. But it just doesn't strike me as the kind of thing that's obvious, that's on its face. Of course, this relates to the defense. So it's like, okay, so it wasn't in the request. It wasn't in the order. It doesn't seem to be of the kind of category that seems to be the kind of thing that, the prosecutor was deliberately ignorant of, willfully blind of, or any of those things. And I can't prove malice. Because I don't have the prosecutor taking the stand with their mustache saying, "It was me the whole time." Right? So I can't trigger any of those things. And so it's like, oh, okay, so the judge was probably correct that all those things. And also, by the way, you have it now. Right? You have it now, which again is the typical remedy. So again, like if Karen Read, just take the hypothetical. If Karen Read had been convicted and Karen Read had said, oh, there's this video that wasn't turned over to me. And assuming the Court of Appeals, found that to be a material error, which is a whole nother set of problems. But assuming they did, the Court of Appeals in that hypothetical would have simply said, okay, conviction vacated, go try again. Here's your Brady material, here's your video, go back to trial, try again. That's what they would have done. Trying to get a Court of Appeals to throw out a conviction completely is pretty freaking rare. That's not the thing. That's not the thing they're used to doing. The Court of Appeals, and for that matter, the trial court, are going to look for basically any other solution to the problem. And if they can find any other solution to the problem, they're going to give you that remedy. See, by example, for contrast, Glossip recently at the U.S. Supreme Court, Glossip versus Oklahoma, where the whole death penalty and the double trial and, withholding evidence and it's a incredibly fucked up fact pattern. Glossip is way more fucked up than Karen Read. I promise you that. We've discussed Glossip. but like it's way more fucked up in terms of like what the prosecution did and didn't do. Okay, that case is fucked up. And it was a death penalty case at that. Okay. And the guy's been tried twice. Okay. And what did the US Supreme Court do? What did the US Supreme Court do? Did they say throughout the case? No, they did not. What did they do? They said, send it back down for trial. Let's give it another go. Now, whether or not Oklahoma will, in fact, try Glossop a third time, who can say? But they can, right? They can. The Supreme Court didn't say, oh, case disappears forever. They said, if you want to give it another go, give it another go. You know, now you have the evidence, give it another try. And that's the typical remedy, right? I'm not making this stuff up. So like when I say that, okay, this person said, unfortunately, the stress I feel from the injustice in this trial cannot tolerate your opinion on exculpatory evidence not being turned over to defense is okay. It's like, well, my opinion is a legal opinion. It's not a moral opinion. I'm not saying it's good. I'm not saying it's bad. I'm saying it's the law. That's what I do. I give a legal opinion. And I'm like, well, wasn't requested. It wasn't in the order. It's not so obvious that seems inherent. There's no evidence of malice. The typical remedy is let's do a new trial, which we're doing already. And therefore, right, therefore the motion should be denied. But that's a legal opinion. It's a legal opinion based on the legal standards, which I just recited. You know, it's not me thinking and the same thing incidentally, like with the First Circuit Court of Appeals, because I've said the habeas will be denied. I said that at the trial level, the habeas will be denied. I was right. The First Circuit is going to deny the relief too. They haven't done it yet, but they're going to. They're probably going to do it this week. It's probably going to be one sentence or one paragraph or maybe one page. It's going to be short. It's going to be non-precedential. And it's going to say, in substance, we're good. That's what the First Circuit's going to do. It'll be dressed up in a little bit legal language, but it'll be one sentence, one paragraph, or maybe a page that says, we're good. Please proceed to trial. That's what's going to happen. And that's just a legal opinion. And if the First Circuit does all those things, which, you know, of course, the trial court in the federal system, the federal court did exactly what I thought, not necessarily for exactly the same reasons I would have thought. We had a little bit of difference of opinion about how we weighed certain elements. So we weren't necessarily like perfectly in line. I was like, no, I don't really like this part of the opinion. I wouldn't have written this part. I would have written something else. I wouldn't have written this section. I wouldn't have written a different section, right? So we had some disagreements along the way in our analysis, but not in a way that affected the bottom line, right? The district judge in the federal court's like, okay, I think it should be denied for these reasons. And I'm like, I don't really like those reasons as much. I like these reasons. And the district judge, you know, hypothetically in this exchange would be saying, but you still think it should be denied? And I'd be saying, yes. And we'd be saying, okay, so we agree. And I'd be saying, yes, we agree. Right? So we agree. And when the First Circuit does whatever they're going to do, which is almost certainly to be like, we're good, right? Again, there may be slight differences in how we think about the problem. We may approach it slightly different ways. But if they say we're good, then I was right. If they say something other than that, I'll be really surprised, which will be fine too. And then hopefully they'll tell me why the answer was something other than I would anticipate. And then we can analyze who had the better discussion of the point. But my statement or my opinion that the habeas will be denied is not because I don't believe that Karen Read is being treated unjustly. That's not the thing. It's a legal opinion based on legal rules and legal standards that apply. And I'm trying to give you a legal opinion. And I don't know what the basis of Melanie Little's opinion on the issue is. I don't know what her rationale is for it. I suppose her view would necessarily have to be that she believes that either this or somehow in combination with other things has reached the point that the fuckery is so real, right, that we should do this thing. And I'm like, no, I don't think so. I'm like, I see the fuckery. I agree with you, there's fuckery, but I don't think it's reached the level. And in my opinion, really isn't even particularly close, incidentally. So this may be a relatively sharp disagreement of opinion, depending on exactly what Melanie Little thinks about the issue. And by the way, this is not me like criticizing her personally, right? Because we're different people and think about things differently. So we may disagree, we may disagree sharply. It's been known to happen among lawyers and sometimes even among judges. And sometimes those judges are on the Supreme Court and they still disagree sharply, right? So it's not necessarily like she's a bad person or I'm a bad person. It's like, even if we disagree sharply, and I'm like, no, I don't think it's close. And she's like, no, I think it's totally there. I'm like, well, we just don't see eye to eye. It would just be based on a legal opinion. You know, I think the standards are really hard. I think it's basically the last resort. I think it's the nuclear option. Melanie Little might be like, time to go nuclear. And I'm like, nah, I'm not ready to do that yet. Even though, incidentally, I'd be doing it because I want to like help Karen Read, which I do want to do. But I don't want to help Karen Read for the wrong reasons. If that makes any sense. Maybe it doesn't. Maybe you don't really care why Karen Read wins. Maybe you just want her to win and you don't really care why she wins. But I want her to win for the right reasons. You know, I don't want to play the ref or the umpire at this baseball game and skew my results to get the team to win. I want them to win because they played the game correctly according to the rules. And that's the right answer. Right? And if they do break the rules, what are the penalties for that, right? And even in our baseball analogy, or even football or any other sport, right? The remedy is not usually like the game is just over now, right? Usually sports have other kind of remedies. Usually it's not like, okay, the team just wins, right? That's not the typical remedy in a sports match either, right? It's like, oh, okay, there's been roughing the passer 5 times, and there's been offsides 4 times, and there was personal fouls twice. So as a combination of all those things, as a result, Team A just wins. Right? That's not usually the remedy. Right? That's not usually the thing we do. We usually look for less dramatic results. And so maybe Melanie Little, I don't know, because I haven't seen what she says, but maybe she's of the view that, well, there's been a lot of fuckery going around, and so game over. And I'm like, no, we can fix it. We have the technology, but I don't know. But it's a legal opinion. It's an opinion based on the facts. And I want her to win, but I want her to win for the right reasons. I want her to win because the state can't prove her case. I want her to win because the state's case sucks. I want her to win because I think the judge should really consider a directed verdict in favor of acquittal. The case is in such shambles. I think a fair-minded judge would actually, and again, it's a tough trigger to pull, right? So this is kind of like sort of that exact same situation in a slightly different context. So instead of the motion to dismiss, how about a directed verdict? Right? Although the thing is, with a directed verdict, the standard is different, right? Because in the motion to dismiss, right, you're basically saying there's no probable cause, or you're saying that what has happened is so bad it's unfixable. Those are the standards in play. With a directed verdict, you're saying that basically no reasonable juror could come to the opinion that the state proved its case beyond a reasonable doubt, because that's the relevant standard, right? So, like, even if it were me as the judge sitting in this case, and the defense said at the beginning of the case, we move to dismiss, I'd be like, no, they've got prima facie. And if they made the motion to dismiss at the end of the state's case, it's like, oh, okay, now it's not, prima facie is no longer the standard. Now it's beyond a reasonable doubt. I'd think about it. Because again, it's like, to my mind, and again, maybe another lawyer would disagree, but to my mind, there's like so many problems in so many different dimensions of the case. The evidentiary picture is in such absolute shambles. There are so many holes in so many different ways, in so many different layers, that I think it would be reasonable to consider the possibility that a judge should enter a verdict of acquittal on the basis that no reasonable juror could possibly find. guilt beyond a reasonable doubt. And if another lawyer critiquing me said, hey, that's a really difficult trigger to pull, you're really not supposed to do that, you're not really supposed to take it away from the jury, I'd be like, you're right, you're not supposed to do it, but I think maybe you should here. And so maybe that's sort of the disagreement. Maybe Melanie Little just thinks, okay, you're not really supposed to do it, but you should do it here. And I'm like, no, I don't think so. And maybe it's just a disagreement for those reasons. But either way, it's an opinion based on the law. It's not an opinion based on morals. It's not an opinion based on some sort of abstracted consideration of justice. You know, yeah. Amber Am says 93 jurors said guilty, 2 count, forget about directed verdict. Yeah, see, that's not quite right. That's still not right. Even if the jury had said 12-0, you could still be asking the question because it's a question of law. This is one of the things courts of appeal do. Now, they don't necessarily do it very often, but it's possible, right? So if the jury had said 12-0 to convict, the trial court or the court of appeals could still be like, no reasonable juror could possibly convict. Now, at that point, it's not called a directed verdict. At that point, it's called a judgment notwithstanding the verdict, JNOV. You may have heard JNOV before, judgment notwithstanding the verdict, but that's what a judgment notwithstanding the verdict is. 12-0 guilty, and the judge saying, no reasonable juror could think that. You're out of your fucking minds. Okay? So even though the jury voted 9-3 to guilt, it doesn't matter, because if they voted 12-0 to guilt, I could still be having the discussion. I'd be like, no, you're out of your fucking minds. As a matter of law, no reasonable jury could do this. But 12 of us did. Yes, you're not a reasonable jury. Congratulations. And again, it doesn't happen every day. It's not often. It's very unusual, but it's possible. It's possible. That's what one of the things that appeals are for, is for such things. It can happen. What the jury did, and then the fact the jury did it doesn't mean the jury was sane. So there is an escape valve at the back end of this thing. Okay? Has it happened on a hung jury before? I don't know. I mean, a hung jury would never be appealed because there's nothing to appeal. But has a judge ever entered a directed verdict in response to a hung verdict? Probably. I mean, I don't know that we've ever seen it, but it's probably happened. Sure, why not? Again, it's not very common. It'd be unusual, but it's possible. So has a judge ever, in response to a hung verdict, been like, okay, how about directed verdict, not guilty? Yeah, I'm sure it's happened. I'm quite positive it's happened. I don't know when, but I'm sure it has. Yeah, no problem. That's what such things are for. And incidentally, by the way, if a judge were inclined to do it, they will typically wait until the jury, because they always want to give the jury the opportunity to get it right. So even if I really thought in my heart of hearts that a directed verdict should be entered at the end of the state's case, even if I really thought that in my heart of hearts, I still might decide not to do it, to give the jury the chance to get it right. And then I'd be like, no, you're out of your fucking minds. And how about a JNOV? But yeah, I mean, still, right? Yeah, all those things. But a JNOV on a hung jury? No, it wouldn't be called a JNOV on a hung jury. It would be called a directed verdict. In response to a hung, it would still be called a directed verdict because the jury returns a verdict. That's what they do, right? And if the jury doesn't return a verdict, then I can't do a JNOV because there's no verdict for me to do a JNOV on, right? JNOV is a judgment notwithstanding the verdict. If the jury comes back hung, there is no verdict. So I can't do a JNOV. But what I can do is I can still do a directed verdict. I can still do a directed verdict. I'm sure it's happened because I'm the one now providing the verdict. The jury's like, I don't know. It's like, but I do. I'll give the verdict. How about no? My answer is no. How about that? Yeah, you can do that. It's just it's a different label for the same thing. It's fine. No problem. It's a directed verdict before saying mistrial? Right. Directed verdict and mistrial are not compatible concepts. They're completely different concepts. A directed verdict is not a mistrial. A directed verdict is the trial. Right. So the jury coming back like, we don't know. Okay. Right. Option number one. Okay. The jury, option number one, there is no verdict. How about a mistrial? Option number two, no problem. I'm going to supply my own exciting verdict. How about not guilty? That's not a mistrial. Now it's just not guilty. The verdict is not guilty. A judgment of acquittal is entered. Everyone goes home. Thanks for playing. Yeah. Can Bev do a directed verdict of guilty? No, of course they can't do a directed verdict of guilty. Absolutely not. This is a one-way thing. Are you insane? No, the Constitution doesn't allow a directed verdict of guilty. You have a right to a trial by jury. What kind of question is this? Of course you can't do a directed verdict of guilty. This is a one-way valve, people. The judge can't overturn a not guilty. The judge can only overturn a guilty verdict or a hung jury. They can do that. Well, strictly speaking, I guess they're not overturning a hung verdict because there's nothing to overturn. But no, this is a one-way valve. The judge cannot do a directed verdict of guilty unless it's a bench trial. If it's a bench trial, then sure. But then it was a bench trial the entire time because there never was a jury. No, they can't enter a directed verdict of guilty. No, that's dumb. No, it's a one-way thing. It's a one-way valve. You have a right to trial by jury. If I solve this problem by how about directed verdict of not guilty, there's no prejudice to the defendant because you get to go home. I really wanted a jury though. Yeah, but you're not on trial anymore. So what do you care? You know, so like, I object. No, no, you don't get to object. Yeah, that's dumb. That's dumb. You can't do that. None of those things. None of those things. That's dumb. So in any respect, back to my original point, I don't agree with the judge. I don't agree with Bev with respect to the motion to dismiss because I like Bev. I don't agree with Bev because I think that she's a good judge. I don't agree with her because I think she's unbiased. I don't agree with her because Karen Reed deserves to go to prison. I don't agree with any of those for any of those reasons. I agree with her because there's a legal rule that applies, and I think the legal standards apply. And I think the judge was correct in the legal standards as she articulated in the document. And I think those legal standards I think her findings are relevant to those legal standards, and I think the judgment is correct as a result. It's a pure legal decision, guys. It's like, I don't know what to do. I don't know what to do. And at bench trial, it's not a directed verdict, is it either? It's a verdict by the trier of fact? Yeah. To the extent it matters, I guess. I'm not sure why it matters what label we're giving it at this point. If it's a bench trial, whether we call it a directed verdict or not. I'm not sure what matters at this point, but yeah, okay, sure. The label is not the thing, guys. I think you're getting a little hung up over the label. Okay, we can call it something else. We don't have to call it any of these things. The label's not the thing. I think you're getting a little hung up on the label. All right, great. Anyways, so anyways, that was one thing, and then. It's a verdict with no direction, maybe. All right. And then incidentally, in response to my previous video I did on the ghost gun thing with the ATF, and I'm like, no, I think the court's right. I got some pushback. I got pushback in chat. So I get pushback. So that was pushback, from one side of the aisle. I mean, although Karen Reed's probably more bipartisan, I guess. But then I get pushback from the right when I don't give them what they want. AEA appeal hearing next? No, probably not, because the Court of Appeals already rendered its decision, so the hearing's moot. They already rendered a decision. They did it today. The injunction remains in place. So there's no point of doing the hearing. So it's moot. So I didn't cover it. Any respect. All right. So with regards to the ghost gun thing. A couple comments anyways. Charles Christensen said, imagine making all the way through law school and being appointed to the highest court in the land and still not understanding what shall not be infringed means. Every time, man, every time with the gun rights people. They always go to what shall not be infringed. They always go to shall not be infringed. What shall not be infringed is the problem. What shall not be infringed? The right to keep and bear arms. Okay, what is that? Right? You have to define what the right to keep and bear arms is before you can even talk about what infringing it is. It's like you have to set up the borders of the thing before you can even talk about what it means to infringe those borders. But the Second Amendment people always go to shall not be infringed. It would be like going to the First Amendment and saying Congress shall make no law. It doesn't do what you think it does. It doesn't mean what you think it means. Or I guess it does, but it only relates to something specific, not something general. So, okay. Talvin in the chat, or Talvin in my comments said, readily convertible is not 8 hours in my opinion. It's a few minutes. Okay. Think about it. 8 hours at $100 an hour is $800 for machinists to finish the frame. I will object to the idea that what makes something readily convertible or not is dependent on money, as opposed to effort or time. I don't think this is a money question. So you were better off with, because, well, the machinist might be doing it for free or not, or they could be charging anything, right? So it's based, the convertibility of the firearm is not dependent on how much it costs. It's dependent on how easy it is to do, right? And if you want to say 8 hours is too long, I think that's fine, incidentally. I'm not wedded to 8 hours. I thought 8 hours was a reasonable thing, but if you said it was less than that, I'd be like, okay, what do you think it is? But at that point, we're sort of having a much less consequential decision. Even if the ATF said 8 hours and you said, I think it's 10 minutes, that's a much less consequential decision than saying, this can't be regulated at all because it's not within the statute, right? At this point, we're sort of like, even the difference between 8 hours and 10 minutes is kind of dicking around on the edge, right? It's like, okay, what number is it, right? And it's kind of still dicking around on the edge. So I don't really care what number you pick at this point, to be honest. It doesn't really matter to me, because like any number is kind of like, if it's 4 hours or 1 hour or 8 hours, I mean, the courts will figure this out as it goes along, what that looks like as they figure it out. But, any answer they come up with, is the ATF right that it's 8 hours? Probably not. It's a reasonable thing to say, but they're probably wrong. But it's not like inherently ludicrous. At least to me, it's not inherently ludicrous. Is it where the courts will necessarily wind up in the end? Probably not. Where will they wind up in the end? Who knows where they'll wind up? But it's like you're arguing over, how many jelly beans are in the jar. Is it 100 or is it 80? It's like, there's jelly beans in the jar though. It's a fairly inconsequential question in the broader scheme of the analysis. So for the moment, it's like, pick your favorite number and I'm fine. It doesn't matter that much to me. 8 hours seems like it could be. Could it be 4? Could it be 1? Could it be 30 minutes? Sure, why not? Could be any of those things. We'll figure it out as we go along. But that's fine. So RJ Stockton sarcastically said, I'm so glad we got all these awesome conservative judges on court. Yeah, I know you're saying this sarcastically, but conservative judges apply the law. That's what they're supposed to do, remember? That's what conservatives said they wanted, remember? Conservatives said they want just judges that apply the law. They don't want judges to invent the law. They want judges to just put the fries in the bag. Remember when the conservatives said that? I remember it, and I still believe it. Even though it doesn't go my way. See, when I said it, I meant it. When I said things like, I think conservative judges are correct. I think that they should apply the law as written. I don't think they should create new law. I think that they should, all that stuff. It's like, yeah, even though it didn't go my way, they're being very conservative. They're being very conservative judges. It's like you fundamentally misunderstand what a conservative judge is, because they're not giving you what you want, because shall not be infringed or something. It's like you misunderstand what a conservative judge is. Conservative judges will say, a conservative judge would be more likely to say, I defer to the legislature. That'd be something a conservative judge would say. We defer to the legislature. It's not up to us to make policy. It's up to the legislative branch to make policy. So we're going to defer to the legislature. They defer to the legislature. They're being conservative. They're being conservative. You just don't understand. You just don't understand. You don't understand what conservative, or maybe you don't understand what conservative legally means, as opposed to politically, because I don't think they mean the same thing. Conservative politically and conservative legally are not the same thing. But they were being very conservative in my judgment. Now, that isn't to say, incidentally, you can't disagree with their analysis. You could disagree with their analysis, but you should do it from conservative principles if you're going to do it. And it seemed plausible to me. A conservative justice would not defer to anyone over the Constitution. Well, as to that, a conservative justice would try to avoid the Constitution if they can. It's literally called constitutional avoidance. It is a foundational principle of conservative legal thinking. We try to avoid invoking the Constitution when we can. And you're still not understanding what the Constitution says in this domain, because you're still stuck on shall not be infringed. So, yeah, all those things. People are making home firearms forever. Now it's become easier to do the work. The government gets upset. Well, be that as it may, that's sort of a dumb argument. People do a lot of things historically, and then at points throughout history, governments make those things illegal for a variety of reasons. It's kind of a dumb argument. It's like saying that something's been legal for 1,000 years, therefore it should continue to be legal. Technology changes. Society changes. The law changes. So yes, the government cares now. Your brilliance is noted. Congratulations. Yeah, way to go. Infringed means taken away in con law. Well, no, not necessarily, but you still have to get back to what the thing is that's being infringed. See, the problem is, what is the right to keep and bear arms? By analogy, what is the freedom of speech? I'll give you a clue. The freedom of speech is not the same thing as speech. The freedom of speech is not the same thing as speech. Just because it's spoken doesn't mean it's included in the freedom of speech. The reason you know this, incidentally, by the way, without me even telling you that, is because, for example, defamation can be banned. Obscenity can be banned. Child pizza can be banned, including, incidentally, simulated child pizza can be banned. Fighting words can be banned, right? Just because it's spoken doesn't mean it's part of the freedom of speech. Just because it's an arm doesn't mean it's part of the right to keep and bear arms. The right to keep and bear arms is a more specific construct. Okay? It's more nuanced than that. It's different than that. Incitement, exactly. Incitement is spoken. Incitement can be banned. Exactly. Right. Incitement is spoken, but it's not part of the freedom of speech, even though it's spoken. Right. Just because it's spoken, just because it's speech, does not mean it's part of the freedom of speech. The freedom of speech is not the same thing as speech. The right to keep and bear arms is not the same thing as arms. There is a distinction. And we could get into the more nuanced discussion about that, but I don't really want to get into that analysis right now because it takes a lot of time. And I've done it before, and I don't really want to do it again right now. But there's a much more nuanced discussion to be had. So and you have to have that discussion before you can even talk about what it would mean to infringe it. Because if it's not part of the right to keep and bear arms, the government can do whatever the hell it wants because it's not part of the right. Right? So you're not even infringing it because it's not part of the right, right? So if you have an arm that is not part of the right to keep and bear arms, the government can do whatever the hell it wants because it's not part of the right. There's no infringement. They're not infringing anything. It's not part of the right. You know, if you had an arm, that is not part of the right to keep and bear arms. If you know that, the government can do whatever the hell it wants because it's not included in the right. So it's not an infringement, right? I mean, that's logic. We get this, right? We understand this? Yeah. But arms are necessary for keeping and bearing them. Some arms are. Some arms are. Not necessarily all arms. Just because you call it an arm doesn't mean it's part of the arms within the Second Amendment. They're not the same thing. They're not one and the same. It's not the same thing. It's more nuanced than that. So all the government has to do is list everything as an arm you're not allowed to have? No, they don't. They're under no obligation to do that. The government's under no obligation to ban anything. That's dumb, too. Why would the government have to provide a list of everything that's not an arm? That's dumb. You want the government to define everything that's not an arm, and you want them to pass a law that defines everything that's not an arm. You want them to go up to the wall. You want them to regulate to the absolute limit of what it is. I don't think you want to do that. That doesn't sound right. That sounds dumb. The government's under no obligation to ban anything. The government's under no obligation to list everything that they want. If they want to ban something, they can add it later. That's dumb. Are you hearing yourself? Yeah, Supreme Court's not decided what an arm is yet. Well, they kind of have partially, but they have partially, but not necessarily completely. And incidentally, that's probably true for speech as well. Particularly as technology develops, there will be new extensions of the concept. Yeah, it's not what an arm is, it's which arms are included in the right. Exactly so. Which arms, and what does it mean to keep, and what does it mean to bear, and is keep and bear one thing or two things? These are exciting questions, right? Which arms, what does keep mean, what does bear mean, and is keep and bear one thing or is it two things? That's a good question. These are as exciting questions left to be discovered. All right, pressing on. The Second Amendment makes no distinction on what is or isn't an arm. The First Amendment doesn't make any distinction what is or isn't speech. I'm going to have a full constitutional analysis discussion, aren't I, right now? That's what I'm doing. Okay, let me help you out. All right. Okay, guys. We're going to have to do this thing, and you're driving me fucking nuts, and we're going to do this thing, but that's fine. We'll do it. All right. Okay. All right. For my money, what court recently erred decides short barrel rifles aren't even arms? I think this is kind of conclusion of the logic Kurt just used. Well, I don't know what court said that. I don't even know whether they're right or not. And it may be correct. It may not be correct. Oh my God. The distinction is a well-regulated militia? That's not it. That's not it. That's not it. The distinction is the. The distinction is the. The is the most important word in the sentence. The distinction is the. The right to keep and bear arms. The word the, or the, is a specific antecedent. It is referring to a specific thing. It's the difference between saying I want the apple versus I want a apple. If I say I want a apple, any apple will do. If I say I want the apple, I'm referring to a specific antecedent apple. There is only one apple I mean. Hopefully you know what that is, because if you bring me any other apple, I'm going to be disappointed and sad because it isn't what I asked for. I asked for the apple. The word the is a definite article. It's a specific antecedent. It's a defined thing, okay? By contrast or by comparison, all right? Another example would be, for example, the land, okay? Let's suppose I say you have a right to the land, all right? What do I mean? Well, I mean a specific piece of land, Hopefully, again, you know exactly what I'm talking about, or this conversation is going to be a little futile, right? There's a difference between me saying you have a right to land and me saying you have a right to the land. If I say you have a right to land, that's very generic. If I say you have a right to the land, that's very specific. And the land comes with borders. The land comes with borders. And those borders may be irregular. Those borders may have pathways through them. Those borders may include a river that perhaps is general access. Those borders may include enclaves and exclaves and all kinds of exciting things that all the friends who do land surveying might know about, right? So the land has borders, but it has borders. That's the key. It has borders. So before you can even talk about so if I said, right, the land shall not be infringed. If I said the land shall not be infringed, before you can even talk about what infringing would be, before you can even have a discussion about that, you have to talk about what the borders of the land are. Because if it's land, but not part of the land, it's not infringement. I can do whatever the fuck I want. It's not your land. I can do anything that crosses my fancy. I can go on land that's not your land and have a party and dig for treasure and put up a skyscraper or anything else I want. You know, at least it's not your land, and you have nothing to say about this bullshit, right? You have nothing to say about it. I'm not infringing on anything because it's not yours. It's something else's, right? So the most important word is the, okay? Now, in the exact same way that in the First Amendment, when we talk about the freedom of speech, the freedom of religion, the freedom of the press, the freedom of assembly, when we talk about these essential freedoms, okay, they are specific things. They have specific boundaries. They have specific delineations. As I said earlier, right, not all speech is part of the freedom of speech. It is literally not within the boundaries of the thing. It is speech, but not the speech. It is land, but not the land. Are we keeping on pace so far in this lecture? Hopefully, because I'm trying to express this as well as I can, right? It's speech, not the speech. It's land, not the land. It's not within the borders. Okay. Now, if you want to know what is within the borders of the freedom of speech or the right of the press or the right of assembly or the freedom of religion or the right to keep and bear arms, if you want to know what's within the borders of these things, the way you do that, as we learned from the Bruin test, is history and tradition. History and tradition tells us. In other words, go consult all of common law. Go consult all of common law and it will tell you the answer, right? The freedom of speech was understood because they understood what they were talking about because of the common law tradition. The common law had spelled out what the freedom of speech looks like. It does not include obscenity. It does not include fighting words. It does not include incitement. It does not include the CP. It does not include these things. It is categorically excluded, okay? And that's how you do it. So the Constitution doesn't define it because it doesn't have to, because it's using the word the. The Constitution doesn't define what arms are because it doesn't have to. It's already referring to a specifically predefined thing. It's the pre-existing right? It's a pre-existing right. The pre-existing right to keep and bear arms. What is the nature of that right? What are the boundaries of that right? That's the same exact question you would be asking about freedom of speech. The Constitution doesn't have to define it because it was defined by the common law. That's the history and tradition test. Okay, and so then basically what you do if you want to do all those things is you go trunch through 700 years of law and you try to figure out what were they talking about and what weren't they talking about. Okay, and only when you do that, can you then have a discussion about what it would mean to infringe it. Because before you even define the borders, before you even get out the surveyors, before you even measure the borders, having a discussion about what infringement is stupid. Because what are we even talking about without defining the borders of the thing? We have to define the borders of the thing first, and then we can talk about what infringement would be. And what does it mean to infringe? Well, I don't know, but there's a whole separate discussion. That's a whole separate discussion, what it would mean to infringe. But we can't have that until we define the thing first. Does everyone understand now? Does everyone get it? The Constitution doesn't define the word armed because it doesn't have to. It's been defined. It's predefined. It's in the common law. Do you get it? Great. So we just can limit the right to freedom of speech based on time. Sounds good. Okay, Zafel, you are getting banned. I'm tired of you fucking bullshit. Fuck you, you're banned. Fuck you. Fuck you, that's not what I said. Fuck you, you're not understanding. And now you're being a troll, and now you're fucking banned. Fuck you. What's the definition of common law? What do you mean what the definition of common law is? The common law is all the judicial decisions from England and the United States since 1189. Maybe you didn't know that. That's common law. Common law is all the judicial decisions since 1189, either in the United Kingdom or the United States, as the case may be. That is common law. That's it. That's the common law. Any other questions? Dude, don't dude me. I will fuck your world. Don't do me. Don't dude me. That guy was being a troll. He's being an asshole troll because I didn't say anything like that. And he's being a deliberate troll. And so he gets banned. And if you want to get banned for being a troll, you can get banned too, but I'm not taking any more of this bullshit. Why I get super chats? Okay, you fucking get banned. Who else wants to get banned today? Who else wants to get banned? I'll do a list. Who's out? Okay. Ryan Jones gets banned. Who else? Dark Side wants to get banned. Okay, that's fine. Who else wants to get banned today? Ban you. Great. Who else? Why they choose 1189? It was just a statute that the legislature passed at one point, declaring it to be time immemorial. I love your passion. Everyone's so scared to speak their mind. It's not an issue of speaking your mind. They're just deliberately trolling me. They're deliberately trolling me. No one gets the right to troll me. That's not. And also, by the way, you have no freedom of speech here. I'm not the government. You have no freedom of speech. I am all powerful. Thank you. The trolls just want you to get mad. I mean, I spend all that time laying it out. I spent all that time detailing it, going through it, spending the effort to illustrate it, explain it, perhaps repetitively, and then Zafal's like, oh, so the government can just say anytime. All right, where were we? Squill says I can make a slam fire shotgun with off-the-shelf parts in Home Depot in about 2 minutes. I guess you could. It won't be very good, but it would work. And it would be a firearm. So you have a point there, I guess. Wow. What wow? What wow? Please breathe. Okay. All right, I've breathed now. 8 hours in a machine shop, I could probably make 10 to 12 guns at that time. If I prep files ahead of time, maybe. Curtis does stuff online, said, what I love is it was the wrong argument. Under the statute, the AR lower and upper does not qualify as a firearms receiver. I'm not even sure that's true. Follow the actual recipe of the Mississippi pot roast and you'll love it. The fuck? Easy as pulled pork butt in the crock pot, covered with apple juice. Respect. I don't know why, people sometimes say I'm repetitive. People sometimes say, I over explain things, and I do it, and I spend all that time, and I lay it out, and I detail it, and still they come up with a really stupid ass comment. That means that anytime the government wants to just say time, then that means they can just do anything they want, because they just do anything they want. It doesn't mean anything like that. Why am I even talking to you if you're not listening, man? In common law, the term arm refers to a weapon, a firearm, or other instrument used for defense or attack. No. Didn't the Supreme Court just make a decision that parts are considered firearms now? Under the relevant statute, they are. Which doesn't mean they're arms within the context of the Second Amendment. So aren't AR uppers and lowers individually considered firearms? The lower is, I believe. Yes. And 80% lowers, and some other degree of lower yet to be described. Lauren said they had an entire video, now they can't even produce it. How's it not egregious? Well, as I said, because it wasn't in the original request, it wasn't in the original order, it wasn't inherently obvious that it would necessarily be exculpatory. It doesn't seem to fall into that category. If they lost the video through normal document retention practices, then that's not egregious either. So if they automatically delete videos, every 30 days or whatever, and the video just got deleted through a normal process, that's also not egregious. It just isn't egregious. It's just not. According to US v. Miller, short-barreled shotguns are not arms. US v. Miller is a very poorly written decision. It's actually hard to read US v. Miller. I've read it multiple times. I'm still not 100% sure what it says. It's not a very well-written decision. It's very confusing. US v. Miller is best ignored, I think. It's not even that I disagree with it. It's just hard. It's literally hard to read. I'm not 100% sure what they're talking about. K. Jameson 05 said, a question in general, how is a new trial fair when the person being accused is having to pay for their attorneys all over again? Well, if they go bankrupt or they run out of money, they can be provided a public defender, and they're entitled to an attorney. So that's how it's fair. I'm not saying it's good. I'm just saying that's the answer. Gravel Gertie said, black robes with judicial immunity, like Beverly Cannoni, indeed usurp powers not given to the Constitution. When they begin pretending that somehow they're giving a monopoly on constitutional interpretation. Well, no, but she's going to make a decision as the judge. That's what she does. That's one of the things she does. And those decisions can be appealed. So to the extent that and if you're just talking about the judicial branch as an entire whole, then yeah, the judicial branch, that's Marbury versus Madison. It's emphatically the duty of the judicial department to say what the law is. And the Constitution is in fact a law. So, yeah. Oh, by the way, I got we're going to do an opening. I didn't do it earlier, and now's a good time. I got this thing in the mail. I know what it is. I haven't opened it. We're going to do an opening now. So this is the braid thing. This is that someone made for me. So we're going to open it up. It's going to be fun. We're doing a post-op. We're doing mailbox reveal time. All right. So let's go ahead and open this up. There's your ASMR. Oh, that looks like there's a note. Let us read the note. Kurt, I hope you enjoy the braid. If you need to clean it, hand washing and air dry should work fine. Sincerely, Torin. Thank you, Torin. All right, and then ooh, exciting. Can Congress, through an amendment, undo Marbury versus Madison? Yes, they can do anything except one thing through an amendment. There's only one thing that they can't do through an amendment. If you want to know what that is, read Article 5. Let's see what we got. Cool. Yeah, it's a braid. See, it's braid. It's a braid. It's a braid. It's got things that represent. It's got the Clemson tiger paw. That's Clemson. Go Tigers. It's got Scales of Justice with my logo on it. UL. That's cute. I guess it's supposed to be this way around, because then that would be right. Okay. Yeah, so it's supposed to be this way around. This is the tiger paw. This is my logo, UL. And then there's the bee fish. That's cool. That's right. That's nice. I'm going to hang that up. Excuse me 1 second. 1 second. Please talk amongst yourselves. Okay. All right, I added it to the set behind me. See, I added it to the set behind me. So now it'll sit there as part of my set behind me. I put it on a little hook though, so people could see it, you know, if I'm sitting in the right position. So it will sit behind me and be part of the set. That's cool. I like that. Very, very nice. All right, cool. Excellent. Very good. All right. Thank you, Torin. It looks nice. You know, maybe I should move the hook so that it's like all the way to the side, because it's getting kind of blocked there. So maybe I'll move the hook, but it'll stay there for the moment while I figure out where it needs to move to. You're a Clemson Tiger? Yeah. You're just now figuring that out? You're just now figuring out I'm a Clemson Tiger, just now figuring it out. Just now figuring it out that I'm a Clemson Tiger. Just right. Yeah. Okay. All right, where were we? Impeachment procedure. Okay, I'll bite. Why can't impeachment procedure be changed by amendment? Auto Doctor, why can't impeachment procedure be changed by amendment? I'll wait. You can't change Article 1, Section 9. Why? Why can't you? Maybe I should have a call-in show. What's that clicking? It's my pen. Article 5 says it has to be done before 1808. No. Read it again. Read it again. It said it could not be done before 1808. Yeah. Also, it had nothing to do with impeachment. That's okay. I'm having a very frustrated day, I can tell. I was having a great day. I was happy. And now I'm having a frustrated day and I'm yelling at chat. Some days it's very frustrating. I don't have enough information about the Nicole Rice verdict to have an opinion. I didn't watch the trial. I don't have enough things. All right, where were we? The Karen Read trial is sad, but a pure example of overreach and obstruction of due process crucial to a fair trial. Massachusetts should be embarrassed, ashamed, and citizens should uprise against injustice. Beth said, since the SUV is the alleged murder weapon, doesn't the Commonwealth have to show a chain of custody of the murder weapon? Yes. With video footage and or clear photos of the entire SUV? No. No. Would be nice, not necessarily required. No. If they have it, then, that's great, but they're not required to have it. They're not required to have video and footage of those things. So yes, they have to show chain of custody the murder weapon. No, they don't have to have video footage and or clear photos. They should, but they don't have to. And Canton was told to step down early in the case. So why is Canton PD allowed to remain involved? Well, I think the idea was that they were using the Canton Police Department headquarters as the facility because it was convenient was the idea, rather than it being them that was doing it. It was just their building, but it's a fair question. What do I think about the dismissed juror following an appearance in the Karen Reed case? To do what? An appearance? What they want to They want to represent Karen Reed? Did they file to represent Karen Reed? Because that'd be hilarious. That'd be great if she wants to join the defense team. I'm in for that. That'd be great. She's on the team. That is fucking hilarious. I love that. That is some class A. That is class A. She's now part of the defense team. Baller. That I like. That I like. That is very, very cool. That is very, very funny. I like that very much. That's great shit. She joined the defense team. Outstanding. That is grade A. I love it. I hope the juror gets to be part of I hope she gets to do some questioning. I hope she gets to participate in some meaningful way. That is chef's kiss news of my day. That is awesome. I'm here for it, man. Probably won't sit. She's licensed by the state. There's no reason to deny her. She's not even pro hoc. She can lead the team. It's another non-pro hoc lawyer. She's a lawyer in that state, right? So yeah, there's no reason to deny her. There's no conflict. There's no prejudice. It's great. It's awesome. I love it. Sounds fantastic. She's a civil lawyer. So what? She's licensed. What the fuck does that mean? She's a civil lawyer. She's not a criminal lawyer? Who the fuck cares? That's not a thing. That is not a thing. I have a license to practice by the state of Texas. It does not on my license say criminal law or civil law or any of those things. That's not a thing. It's not really a thing. Lawyers choose to specialize, but they don't have to. She's a civil lawyer. Well, so am I, typically. But if it's like I want to be a criminal lawyer today, I can do whatever the fuck I want. I have a license. It's great. Yeah. The only thing the license doesn't allow me to do is patent law, but I have that from the federal government, so I got one of those too. I can practice all the law. I can practice every law. I am all powerful. Blah, 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 ha, 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 ha. Are there boards for specific areas? Sure, but boards are not required. You don't have to be board certified. A lot of lawyers aren't. A lot of good lawyers aren't necessarily board certified. I don't think it means as much to lawyers as it does to doctors. I couldn't say, but it's like board certification doesn't really mean anything to me. It doesn't stop me from doing anything. I don't know whether being board certified like stops you as a doctor from doing certain things or not. Maybe it does. I don't know. But as a lawyer, board certification is optional. It doesn't stop me from doing anything. I can do anything. I'm all powerful. I'm magic. Have I heard of it happening before? Sure. Yeah, I've heard of lawyers switching sides before or doing different things. Not necessarily successfully, but yeah, absolutely. I've heard of it before. Yeah, 100%. It's a little unusual, but it's not like totally unheard of. Yeah. What's the point of boards? I don't know. Bragging rights, I guess. I don't know. I don't know. The only thing where I think it could pop up would be if maybe death penalty certification. But even then, I don't even think it's necessarily required. Maybe in some states it is to be death penalty qualified as a lawyer. Although even then, I think that that's only for the public defender that they're required to do as the public defender. So I don't even think you have to be, I could double check, but I don't even think you have to be death penalty certified to take on a death penalty case. So hypothetically, my first case could be a death penalty case. Now, I'm not really sure that's a really good idea for any number of reasons, but I could. Although my client would have one hell of a ineffective assistance of counsel argument going for them, but that's another problem for another day. Have I heard of a former juror becoming a defense lawyer on the second trial? No. This is a first, but I'm definitely here for it. I'm here for this. This is great. I love it. I think it's awesome. Yeah, I think it's awesome. This is great news. This puts a smile on my day. Bev is incorrect. Unetti made a motion that was approved to preserve all police video and turret video relating to the case. Yeah, but when did they make the motion is the thing, right? In response to various things happening, the timeline matters. So he didn't make the motion with respect to the timeline that was being discussed in the case. No. Additionally, I've heard it argued the vehicle is the murder weapon and actually the crime scene in some states. Well, it is the murder weapon, but actually the crime scene, well, it could be the crime scene, but yeah. Do lawyers ever catch flack for when an appeal goes through for ineffective assistance of counsel? Well, they get sued for malpractice, and they get their insurance pays money, and then they have trouble being lawyers and stuff. All right. So let's do something else that's going to piss me off and everyone else off. Let's respond to another email. This one dealing with transgender issues, because that sounds exciting and fun. Lord have mercy. Zafael, by the way, really had it coming. I'm getting banned. It's not the first time he's gone under my skin, by the way. So he had it coming. He had it coming. And then the other guy who's like, I'm out, just decided to hop onto the train for some reason that seemed retarded. So if you're wondering like why I reacted the way I did to Zafael, he's been pushing that envelope for a while. He just found the limit today. He found the limit today. Can you appeal a case you've tried and claim ineffective assistance of counsel and be the main appellate lawyer? I think you wouldn't be able to do that because you'd be conflicted out. You can't really argue against yourself like that. So I think it would be a conflict of interest. So I don't think you could do that. All right. So anyways, here was an email I received on some transgender issues. This is going to be exciting. This email was entitled Trans Discussion Stream. This isn't going to end well. And incidentally, in that discussion stream, someone left a comment saying, well, it's time for me to not be a part of your channel anymore. And I'm like, well, okay, bye, I guess, because I don't know what to do with that. But again, no names, but this was an email I received. Hi, Kurt. As I write this, I'm watching your Professor Dave Explains video. Just in case you don't make it to the end of this email, thank you for the work you do as Uncivil Law. I enjoy your commentary and your blunt approach, no bullshit. We'll see if you continue to enjoy it through the remainder of my response. I want to engage with you, but your chat isn't ideal. Fair. Your reasoning is justified as for striving to understand. Having this Dave guy try to explain something he can't comprehend is troubling. Yeah, I know you're just commenting on his video, and I think you're spot on. So it's like, yeah, so this guy wasn't doing a very good job explaining something, and I'm like, what he's saying doesn't make any sense. And so that was my critique. Cool. Problem is, it's so much deeper than one or the other. It's like saying what makes you, you. Okay. I'm confident in saying you regard yourselves as male, but why? Well, from my frame of reference, because we discussed this earlier, gender and sex are the same, and therefore XY would be the answer to the question. So that would be why. And then the person continues. You could argue you have male parts, or you have tested and confirmed your chromosomes, but let's take them out of the equation and ask what makes you male. Well, you see, you can't do that. You can't take them out of the equation because that's my definition. Now, you can disagree with that definition. You can say that that's not a good definition. You could say you should have some other definition, but that's my definition. Sex is gender. They're one and the same. what makes me male is X, Y. And then you say, we'll take them out of the equation. It's like, okay, you've just undermined my definition. And then you want to ask me what makes me male. Well, I have no answer because you've just taken away my definition. But I had a definition to start with. So the analogy doesn't work because Dave didn't provide a definition. I provided a definition. Then he said, well, what if you didn't have the definition? Well, I was like, well, if I didn't have a definition, then I'd be screwed, but I do have one. So yeah. Reason for putting it that way is to be the same level as me. My anatomy and chromosomes were part of my equation. In my view, they were wrong. Okay, cool. So like you think your anatomy and chromosomes are wrong. They don't match you in some way. So you have a different definition, presumably, of sex and or gender. Fair enough. And hopefully you'll provide that, and I can have some sort of constructive discussion based on that. But then the question is, what makes you inherently you? Well, I mean, I could provide some traits that are inherent or that are at least more solid. And if you ask me why those traits would be true, they basically boil down to a combination of nature and nurture would be the answer to that question. Would be why I'm me. So at the core, a combination of genetics and upbringing, nature and nurture. That's sort of the answer. And if you wanted more precise answers, we could try to give more precise answers for particular traits, but I'm not sure how useful it would be, but that we could do that in principle, or we at least could try to. I'm not going to pretend to know or understand. I just have this drive to be as female as possible. Okay. Yes, I like finer things, dresses, and things that are culturally seen as female. But I drive excavators, can fix mechanical equipment, and don't mind getting dirty. But these also don't really matter. In my years of service in the Army, I've in a different country, incidentally, than the United States, I've seen women outperform men in various things. I believe that. I've met female mechanics with more ability than some counterparts. I believe that too. So these things aren't exclusive to one gender or the other. I agree with that. I have no problem believing that there are some women who are better than some men in some things. I have no problem with that. Although I take note that you haven't really, your only thing that you said when you said, I have this drive to be as female as possible, you referred to finer things, dresses, and things that are culturally seen as female. So that's sort of your only definition of female, which I guess is better than nothing. But then you say also that you do things that are not culturally female, which then undermines your statement, right? So it's a bit confusing, right? If you had the drive to be as female as possible, then presumably you would be driving to do all things that are culturally seen as female or close to it. But you don't do that. You do things that you acknowledge are not female, or at least inherently female. And you don't see any problem with that. Incidentally, I don't see any problem with it either, that you have these things that are not female. It just seems to undermine when you said, I have this drive to be as female as possible. So if female is not exclusively cultural or cultural norms, if female is not exclusively cultural norms or gender stereotypes, if female is not gender stereotypes or exclusively gender stereotypes, I'd still want to know what is female exactly. Because you say you want to be female as possible, and it also seems like you're saying, if I'm reading this correctly, that gender norms, the fact that you're not strictly female in your gender norms doesn't make you not female. Which I understand that, but I'm just a little bit confused what your definition of female is. What does it mean to be female as possible? Like, what does that look like? So it's a little bit vague in your email, to my mind. So again, the question is, what makes you you? Well, I mean, again, we could go to traits and nature and nurture and stuff like that. But the question is, what makes me male, I suppose, and I already answered that question. That's the real question. How do I deal with chromosome abnormalities? Well, I don't fully know the answer to that question, but I don't necessarily need to for the definition to be useful. So the definitions don't necessarily have to be perfect for them to be useful. The more complete the definition is, the better. The more it covers every possible case, the better. But it doesn't necessarily have to be perfect. So I don't necessarily know how to deal with chromosomal abnormalities. But I don't necessarily need to, because I have a definition that works, let's say 99.9% of the time. And, for the purposes of discussion, that's good enough. And if you had a person that had chromosomal abnormalities, then because it's relatively few people comparatively, we could try to deal with that as applied. And maybe we could try to come up with some sort of rules for what other things to look for that would go beyond chromosomes. So maybe if the chromosomes no longer work now, we can go to some sort of secondary criteria. And what those is, I'm not sure, because I haven't really thought it through. But I don't really need to think it through right now, because I'm not trying to fix the entire problem. I'm just trying to come up with something that makes sense. So hopefully that answers your question. Sort of, I don't know. And also, for the sake of most discussion, doesn't really matter. It's a rounding error. So I can kind of ignore it for the purposes of useful discussion. And then the second question was, hold on. How do I deal with body dysmorphic disorder? Well, what is that? Body dysmorphic disorder is a mental health condition where a person spends a lot of time worrying about flaws in their appearance. I really don't understand your question. I don't understand how it relates to what we're talking about. I'm confused. You're not listening to this? You don't need to announce that you're not listening. You can just not listen. You don't need to tell me. This is not an airport. Thank you. They're insulting you? Okay, maybe. Let's see. Where were we? So again, the question is, what makes you you? All right. I don't know for myself. I know I was self-harming, wishing as a male because I was male. Am I happier? Yeah, sort of. I'm not able to live fully. People say they have the right to say I'm male. Okay, well, I mean, if that's their opinion, then they're just speaking truth is from their point of view, or even their truth, if you like that. But yeah, I don't want the right to be called female, just to be respected as a human being. Okay, fair enough. I want you to be respected as a human being. I also want to be respected as a human being. We all want to be respected. So if there's some way in which you're not being respected as a human being that doesn't infringe on my rights, then, I'm interested. But, you can't make everyone else believe the way you believe. I know, because I deal with my own chat. It's not necessarily the one and the same, but still. I say this with this in mind. Calling me female costs nothing. Well, potentially it does, because it costs truth, right? If I don't believe it, if I don't believe it, then I'm lying, because I'm, from my own point of view, saying something I know to be false. So it does cost something. It costs a lie, because I'm saying something that I believe is knowingly false, which makes it a lie. So it does cost something. It doesn't harm anyone physically or psychologically. It inhibits my freedom of speech. It inhibits my ability to represent my own thoughts, or inhibits my ability to have dialogue and disagree. So it does that. It might not sit right, but it would get on with your day, and that's that. I'd feel good and get on with my day and appreciate it. Well, I appreciate that you would appreciate it. I would appreciate a lot of things too, but from my point of view, it would be a lie. And I don't think you would appreciate being lied to. I hope you wouldn't appreciate that. Maybe you would. Maybe you don't care if you're being lied to, as long as it's what you want to hear. But I try to avoid lying when I can. I'm not perfect about it. I'm a human being. Sometimes I lie. Everyone lies sometimes, but I try to avoid it. I try to tell truth. Potentially criminal. How are you doing, Sean? The email continues. Call me mail also wouldn't cost them anything, and wouldn't do harm to them psychologically. Calling me mail also wouldn't cost them anything. That's true, because from their point of view, they'd be saying the truth, and wouldn't do them harm physically or psychologically. However, I'd be gutted. It would prey on my mind. I'd forget it quickly. I wouldn't forget it quickly. Maybe that happened a few times in a day. It would tear into me and cost me psychologically and probably physically. Well, that's not good. I don't want that to happen. And I probably would just try to avoid it if I were talking to you in particular, right? I wouldn't call it out. But I wouldn't call you a woman. But I wouldn't go out of my way to call you out on it either, because there's no reason to do that in a person-to-person context. If we're having a public discussion, if we're having a discussion about what things are, then I have to say it because it's a public discussion and we're having a discussion about ideas. So if we're talking about ideas, I'll say it. If we're dealing with, people, I'm not going to go out of my way to say it, despite whatever I think internally. There's no reason to say it just to, be like, I think you're really a man, or you're lying. Some people might do that, and maybe they have the right to do that, but it isn't necessarily nice. So I value that. So hopefully we have some alignment there. So rights above all else, even have as a cost. Well, that much is true. A right is by its nature personal and belongs to each person individually, and even if it costs someone else, that's true. That's in the nature of a right. Yeah. So my right to freedom of speech, cannot be counterbalanced by cost. That's true. It doesn't necessarily mean it's nice. It doesn't necessarily mean I should do it, but it is a right. Right? So that's true. I have the right to do it. I might be a jerk, and you have the right to think I'm a jerk, but it's still a right. Yeah. My right to my land, right? My right to my land is the right to exclude everyone else. That's in the nature of the thing. Yeah, my rights infringe on the entire world. Yeah, my rights infringe on the entire world. This is my land. Only I can be here. Literally no one else can. My rights can and do infringe on the entire world. That's in the nature of rights. Yeah. That's the thing. That's right. Yeah. I believe we all have rights, but not at any cost. Rights can be measured to accommodate respect to each other's. Again, respect is nice. Society is nice. Treating people respectfully is nice, but not in the nature of rights, right? I mean, should I allow you to cross my land? Maybe. Do I have to? Typically, no. Does that mean I'm being mean? Does that mean I'm not accommodating you? Maybe. But yeah, in the end, if it's my right, I don't have to accommodate you. And you don't have to accommodate me in the end. When push comes to shove, that's what it means. Yeah. And when you start going away from that principle and you start trying to balance them out in other ways, you run into problems real fast, right? So, yeah. Continuing with the email. To put simply, there's no answer to your question yet. That's a bit frustrating. It's like, I just want you, what I really want you to do is just tell me what you think being female means, as opposed to being from a genetic from a mental perspective, from a gender identity perspective or a gender perspective. Like, what does it mean to be female from that perspective? What does that mean? Right? And you're like, okay, there's no answer to that question. And it's like, I can't do anything with that. I need an answer to the question. And again, it doesn't necessarily have to be perfect, right? Perfection would be nice because then we could have a perfect category. But perfection and categories are hard, as we discussed earlier with genetics, right? It's like, okay, my category is XX versus XY. And you're like, how about all the rest? And I'm like, I'm hand waving it away, right? I'm just hand waving it away for the rest and be like, poof, I'm just pushing it to the side, which I can kind of do because it's so low that I can kind of push it off to the side and just be like, it's imperfect, but it's good enough to work, 99% of the time. And that seems like it's good enough, right? So like, I appreciate that you are biologically male and in some sense, you feel some way that feels not connected to that, or feels like your parts are wrong, or your something about your biology is wrong. Let's make it more general than that. Like something about your biology is wrong. Your mental version of yourself does not accord with your biology. And it's like, okay, now you seem to understand your biology because, you said earlier, like, that you were biologically male. So you understand that. And then you're like, okay, so then as to gender or gender identity, like, what does it mean to be female? And again, this could be like the best you came up with in your email was alluding to gender norms. Like you said, the finer things, dresses and things that are culturally seen as female. But then you undermined that by saying you also do things that are not seen that way. So it's not, gender norms might be part of it, but not dispositive. So gender norms are part of it. And maybe there's some other things you could point to beyond gender norms and be like, well, it's gender norms and it's also like these 8 other things. And I'd be like, oh, okay, I understand. And again, it could even be as simple as, and I think this is probably the real answer in reality, if I had to guess, for most people. I think what it probably is something like, I've met 1,000 men. I've met 1,000 women. I have now extracted, based on 1,000 men I've now created in my mind the prototype male. Based on 1,000 female, I've created the prototype female, right? I've extracted from the 1,000 examples the category, right? I created the category from the examples, right? I couldn't define it in the first instance, but I had 1,000 people who are male, and now I can define the category by their membership, and I can look for their common traits. And then it was basically, which of these groups do I feel more comfortable with, right? That seems like probably what the answer is. It's like, I met 1,000 men, I met 1,000 women, and I know from that what men are like, and I know from that what women are like, and I more closely associate with what women are like. That's probably the answer if I had to guess. And even if that was the answer, I'd find that to be satisfactory. I'd find that to be a satisfactory answer. It would answer the question. It's like, okay, my biology is based on chromosomes, and my gender identity is based on, I've met 1,000 people who say they're men, and I've met 1,000 people who say that they're women, and I feel closer to the category of women. And that would be a definition. And that would be workable. I could work with that. And if it isn't that, if that's not the definition for you, if it's something else, I'm happy to hear that too. Because then, once you give me a definition, I can work with it. And I can start playing with it. And then eventually I might say, I agree with that definition, or I disagree with that definition, and here's a different definition, or I might say a lot of things, but I can start playing with it because I have something to work with. You know what I mean? That's what I'm talking about, right? So, yeah. But all I can offer on substance is research that was done on the human brains. There's a difference between a male and female brain. Physically, one is bigger than the other, but the other is dense. So it's argued that they operate different to one another. The brain of a trans person was also said and found is sat between size and density. And even that would be, if that's the answer, that the male and female brains differ in physical ways, and the brain physically in a trans person is closer to that of the opposite sex, if that's the answer, that would still be an answer. And I would accept that answer for the purpose of discussion, and then I could then, of course, play with it and, go from there. And maybe I'd agree, maybe I'd disagree, but, I could then go research it, right? If you said to me that, the difference between male and female is physically in the brain in terms of size and density, I'd be like, oh, okay. And then I could go research that and try to figure out whether that's true or not. And if it were true, that would be really interesting. And then there would be at least a way in principle to measure it. Then it would be objective. It would no longer be something in the mind. It would literally be the brain as opposed to the mind. And I could literally measure it, at least in principle. And then I could know, presumably, whether you're trans or not based on my measurements, which would be cool. And it would be objective, and it would be material, and a lot of other things. That'd be cool. So if that's your definition, that's fine. And then I could go play with that for a while. It's like, but maybe it's that, and that'd be fine. But let me know what it is so I know what to play with, right? Before we can move on. This is like, again, this is the same discussion I was having with you guys earlier about like the right to keep and bear arms. First, we have to define the thing. Right? First, we have to define the thing before we can play with it. Right? First, we have to define the boundaries before we can even talk about infringe. First, we have to talk about what female is before we can even talk about anything else relating to that. Same idea. It's like we have to define the thing first. And it doesn't have to be perfect. It doesn't necessarily have to be uniform. The more uniform, the better. The less abstract, the better. The more it covers every possible case, the better. But whatever. Discord tomorrow? What about Discord? In terms of what? You want to have a discussion on Discord? We could do it now, theoretically, once I finish this email. If you want to have a talk about it, we could have a talk, and then, we could go from there. Yeah. This subject? Yeah, we could hop on a Discord call if you want to hop on a call. That'd be fine. Let me just finish this email first. All right, where were we? The email continues. I tell you my story, but you might give up on life. And then crying emoji. Anyways, if you make it to this point, I'd like to thank you for taking your time. In the Army, again, not this country, a different country, they give their job, which I'm not going to question. And then they say, if you have questions relating to that, you can fire an email. Thanks again. And says the person. And that's the end of the email. Brain research is inconclusive. Yeah, I believe that's true. I think the brain research probably is inconclusive. But, it's something to play with. So, yeah. All right, so we're going to have a call-in show, I guess, now. This should go well. Let's give this a shot. All right, so let's see. I have to change my audio sources. Okay. And then I have to hop in a Discord channel. And I will hop in general. General is a good channel to hop into. And let's see. And I have to unmute myself so you will be able to hear me through the call. And then I have to make sure that my Discord audio is coming out through my earbuds so I can hear you. Where is the setting? Is it voice and video? That would make logical sense. Output device. Yes, that should be correct. All right, so we'll give that a shot. Okay, so I'm now in general if someone wants to join and talk. Yeah, the checks were removed because they were gatekeeping. This is the problem, right? This is a lot of why the left does not want to define things, because any category by any definition excludes. Any definition excludes. And they don't want to exclude. They don't want to say gender norms, because then they have to say gender norms are real, and they don't want to do that. So they don't want to pick any definition. And it seems to me they don't even want to pick the brain, because, then it would be physical and measurable, and you could do a test for it, and you could say whether or not someone is trans or not, presumably. So, yeah. So I will give it a chance for someone to join. I'm just waiting now. Not going to wait forever. So the number, it's on Discord. You said the Discord. You said Discord. I'm on my Discord. I'm on the channel. Yeah, waiting. Hello? M?
Hello.
Hey, what's up?
Yeah, not much.
All right, what do you want to talk about?
Grand jury system. Why do some states not have it?
Well, some states don't have it because the U.S. Supreme Court said it was not part of the fundamental rights when they were doing their incorporation doctrine. So when they threw out the Privileges or Immunities Clause in the 14th Amendment, they then went to piecemeal incorporation through the Liberty Clause of no state shall deprive anyone of life, liberty, or property. And so they threw everything into liberty, but they did it piece by piece. So for every single provision of the Bill of Rights, there's a case somewhere that says that the case is incorporated. And basically it comes down to whether or not essentially it's part of the essential fabric of our Constitution. And the Supreme Court, when it was asked about grand juries, said no, it was not part of our essential fabric. So it was not incorporated. As a result of that, states are not required to do it. And so about every single state has it on the books. About half the states don't use it at all. And for the remaining half, most of them who do use it only use it for like really high level crimes like capital murder. So that's the legal answer to your question.
Awesome. Thanks.
No worries. What else? How does grand jury testimony get excluded from the hearing? Oh, that part's easy. A grand jury, the term grand jury is somewhat unfortunately named. It's a very poor name for what it is. Grand juries are and always have been an investigation tool. They were always secret because they are basically akin to what the police do now, which incidentally is why a lot of states don't use them, because they don't use them for that reason anymore. Now those roles from the grand jury have been devolved principally into the police, so that they don't really need them anymore, right? So grand juries are investigation tools. So the reason that the reason is that they're secret because investigations are secret. And that's the answer. And then like the testimony is not brought in except to the extent you need to. You just don't dump it into the open because it's secret. So that's the answer. And remember, grand jury is also, the burden is exceptionally low. You only need a simple majority. Grand juries are typically 23 people. You need 12. You need 12 of 23, or 12 of however many people are there. So you don't need all the people there. You need 12 votes. There can be up to 23. They're usually not all 23 there at the same time, because grand juries also tend to go on for months and months and months, because they tend to be for longer periods of time. But anyway, so you need 12 votes, and they only need to be probable cause. So you only need a simple majority to say there was basically some evidence this person did it. It's a very low standard. But the nice thing about grand juries is they can have a lot of power. They can be used also for investigation tools. They can issue subpoenas. They can do stuff. Can't hear the caller. There at the moment there is no caller. I'm just responding to chat while I'm waiting for someone else to pop up in the Discord. Just waiting.
Does Texas have a grand jury?
I don't know. It wasn't on the bar. Oil and gas was. The Railroad Commission deals with oil and gas, which I find to be hilarious. The agency that regulates the oil rights is called the Railroad Commission. They have nothing to do with railroads. They regulate oil. I find that hilarious. There's some historic reason they're called that. I forget what it was. Like at one time they did regulate railroads, and then they threw oil in there, and then they took the railroads out of the Railroad Commission, and now it's done by someone else. So now all they deal with is oil. What can you do? You had to mute YouTube audio to get through the echo. Oh, fair enough. Yeah, there might be some echo because I'm going through Discord and going through this at the same time, so there could be some echo. They need 9 out of 12 to indict. There you go. I'm still waiting for that one person who wanted to join the Discord in the first place. That's the whole reason I said I'd do it, and then they don't want to join the Discord. They said, "Can we have a Discord?" I'm like, "Yes." And now they're not joining my Discord. So this is very annoying. Yeah, Phil Biggs said, "Can I join your Discord?" I'm like, "Yep, you sure can." And then I opened it up, and they're not actually joining. This is annoying. I'm not gonna. Hey, what's up?
That person typed in the general chat saying that they want to talk to you in private, but I posted in there also to get your thoughts on the lawsuit that just got brought against Trump's cabinet for Federal Records Act violations and stuff like that. And I just wanted to say you're always doing an outstanding job, and keep it up. All right.
Thanks. Yeah, I mean, I don't really necessarily have any particular opinion off the top of my head. Now, I will note that the White House is often treated differently than the agencies. So, for example, the Administrative Procedures Act, the APA. The APA does not apply to the White House, but it does apply to agencies. So with respect to, and also incidentally, this can be a thing with like the Office of the President specifically, separately and apart from the White House and apart from the executive. So for example, like presidential records are treated differently than governmental records. And when we say presidential, we mean literally the president and the office of the president. So with respect to your particular question, with respect to record keeping stuff, I don't know necessarily what rules are required or not. If they're talking about with the issue relating to the war planning and stuff like that, that went out on the thing, then I don't know the answer to that question off the top of my head. The fact that it involves, for example, the Secretary of Defense, who would be in charge of an agency, namely the Defense Department, then might mean that those records have to be kept and preserved in a particular way. So I don't think, for example, it would apply to J.D. Vance. And I don't think it would apply to Trump. And it might not necessarily even apply to other people in the White House, but it would presumably apply to the Defense Secretary in terms of how those records are kept and maintained. So that's possible that there's been some violation there.
Well, it can apply to them up to the point of Trump giving them a pardon, right?
Well, the pardon would only get them out of criminal responsibility. It doesn't solve the problem of the Record Keeping Act itself, because the record keeping rules are civil in their nature, and you can't pardon out of a civil rule. So the record still, to the extent it exposes criminal liability, that's true, but it would still be a violation that could expose the government to some sort of civil liability that you couldn't get a pardon out of.
Can a pardon be used to get rid of a fine, like a monetary fine?
If it's civil in nature, the relevant precedent suggests no. I don't think this. I'm not sure the Supreme Court has ever said for sure, but there has been a serious discussion that. Well, I suppose it depends. I guess if the civil penalty is really a crime or not, like because it's not just the label, right? So if it's really a crime, maybe. But can it just get you out of a simple civil fine? No. Like for example, the president can't pardon you out of not paying taxes. Right. And so that would be an example. Like he can pardon you for because not filing your tax paperwork or lying on your tax paperwork is a crime. So if you didn't file it, you lied on your paperwork, that's a crime. But he can't pardon you out of, you still have to give them the money. He can't pardon you out of that money. So hopefully that answers your question.
Yep. Thanks a lot.
No problem.
Actually, Kurt, I
Yeah.
have something I could add to that.
Yeah.
I was talking to some people because, I'm in HLC, Habitual Line Call Search chats as well. It came across that it looks like we have a Colonel Vidman situation. It is a leaker who may have added the individual who was trying to get Hegseth in trouble.
Perhaps. I mean, I can't obviously intelligently speak to that. That's possible.
But that's something that is being investigated. So I was just wanted to let you know that's the scuttlebutt going around the military right now.
Fair enough. I also have no particular trouble believing that Signal, for all of its benefits, is not necessarily a normal channel for communication, or perhaps shouldn't be. I think people who are comparing the situation to the Hillary email situation are making a valid comparison. Hillary was obviously Secretary of State at the time, and she kept things on her own private server, which was not an authorized channel. So first of all, it wasn't an authorized channel. Second of all, it was classified material, and so it wasn't being kept properly. And so this is comparable to that situation.
Well, it is and it isn't, because the Defense Department has used this in the past.
You know, for the $800 billion you and me are spending every single year on defense, the fact that they have to somehow resort to Signal is not making me feel any better.
No, I agree with you. As a matter of fact, Ryan Macbeth has already said that he is willing to lend his coding expertise to try to develop something.
How can the Defense Department not already have 8 different things? That's what I want to know the answer to.
I want to know that as well.
$800 billion, man.
They were sponsoring Drag Queen Story Hour on base. Sorry.
Okay, there you go. That answers that question. Yeah. Thank you for your question. I'm liking Q&A time with Uncivil. This is good.
Just got to correct the record, Kurt. It's actually around 1.2 trillion for the DoD budget, but you know.
I really wish you hadn't said that right now, to be quite honest.
Yeah. I had to put some reality check on.
It starts with a T now.
Yeah, if you look at it discretionary, it goes up to like 1.2 trillion.
Yay.
And that's just what they tell us they spend. Let Doge get in there and take a look at it.
Oh, they've already cleared out a good bit already. They're still going through, and I think the last tally was they cleared like 400 billion out of it.
Yeah.
Well, you know, it's like what was they going over where they was talking about they had given like 11 billion for 4 submarines, and they didn't even get 1 submarine out of it. It's like, where did it go, you know?
Yeah, I don't know the truth behind any of those things. Obviously, I'm supportive of trying to figure out where our money is being misspent. So I have no problem with that. And of course, we get into the legal issues relating to that, relating to the Congress and budgeting and a whole bunch of things on legal issues. And then, of course, one of my continuing frustrations is, of course, because I'm conservative and I'm Republican and I voted for Trump. And then it's like, okay, then I'm also going to turn right around and be like, well, I'm not 100% sure this is legal. And sometimes I get pushback and I feel like I'm a traitor to the cause or something. I don't know, man. It's a little frustrating.
Well, you just have to realize that Trump doesn't. Sebastian Gorka just had a thing with trigonometry, and Sebastian Gorka stated that Trump isn't an ideologue. You know what I'm saying? Like, he isn't like got some thing that's holding him in place morally or ethically or anything like that. He's got a problem solve and business dealing stuff going on, you know. So it's not against the MAGA group or whatever. It's what's going to be the correct thing that Trump sees happening and what he thinks is going to solve that problem. And, you know, just like voting for a president, it's a roll of the dice every time you roll it. You know?
Yeah, which is one of the reasons, incidentally, like I caution people when they get a little bit frustrated by, for example, some of the courts or what they're doing. Because I was like, the very things that are impeding Trump are the very things that impede any particular president, right? This is the thing. I understand that some of you guys are frustrated. I get frustrated sometimes too. But a lot of these breaks were put in place specifically because we don't trust the president or anyone else. And so we put a lot of these mechanisms in place deliberately trying to slow things down to try to make things a little bit more constrained. And that's a little frustrating when you're the one holding power. But of course, you know, you won't hold power forever. And people are like, let's wasn't it Mitch McConnell or someone yesterday who said some stupid shit like, let's abolish the federal courts? Floated that idea. That's a brilliant idea. Let's get rid of the federal courts so there are no more federal courts to stop the executive branch. That's a genius idea.
There would be a federal court, because aren't there courts on native land, so that all the states would have to
they
go
don't
to
really count.
Native tribe court.
They don't really count for the purpose of this discussion. They don't really count. The only position you have to have is the Chief Justice. That's the only position you have to have. Congress can pass a law and get rid of every other position. So they could get rid of every other court and every other position, and all you'd be left with is just the Chief Justice, who would only hear cases of original jurisdiction. So it's like, yeah, you can get rid of all the federal courts, but, you know, when, you know, suddenly President AOC don't come crying to me about it, you know?
Yeah, but wouldn't that technically be an even bigger roadblock?
To what?
Because you'd have somebody that's in there for like 30 years as a roadblock, because you know exactly how they're gonna, you know, dissent or concur on or agree or disagree with whatever that's getting put in front of them, right? Because it's just one person.
Yeah.
Well, I've had an idea, but I don't know if it's even possible to be done. Some of the judges we've been running across are not native to the United States. Some of
That's
them
possible.
are not
Yeah. Mm-hmm.
trained in our laws. They're in common law trained, but they're not trained. The United States works in a very unique fashion. We are more akin to the Iroquois Nations Federation than we are to the European styles of government. And because of that, should we not have a block in the federal court that, yeah, you can serve in state courts, but you get up to the federal, no. If you've been here 5 years, no.
Well, the founders didn't see fit to put any particular criteria for the Supreme Court or any other court in the Constitution. So all you need is the confirmation, as the appointment by the president and the confirmation by the Senate. It doesn't have to be a lawyer. Some of the justices in the past, I think some of them didn't go to law school, and I think some of them might have not even gone to college in the past, to be fair, although I wouldn't swear to it. But, you know, it's been an interesting ride.
Can Congress add an additional check on that?
No.
Or can't?
No, because the criteria is in the Constitution, right?
Yeah.
So
yeah.
So you couldn't really change it. Yeah. I mean, I suppose you could put something in the procedural rule. You could amend the rules of the Senate, and you could do it that way. But of course, any future Senate could change them by changing the rule, so it wouldn't be permanent. So you could do it that way, because the Senate has the right to consent, right? Give consent, and that consent can be based on anything. And so the Senate could say, well, we're going to insist that, whatever, they're all US born, they're all US law school trained, whatever they could be. And the way that they would do that is by procedural rule. They put it in their rules. But those rules, of course, can be changed by any future Senate because one Senate can't bind another Senate. So that's as close as you're going to get.
Opinion on background check forms and having to incriminate yourself, possibly?
Again, you could do it by rule. That's as good as it's going to get.
Well, it was a thought.
Yeah.
Well, I'm sorry. Topic change. Background checks on purchasing firearms. What's your opinion on the self-incrimination for checking boxes or not checking boxes?
Well, I mean, you're not forced to self-incriminate because you're not forced to check the box. It's just if you don't check the box, they won't give you the firearm. They're not forcing you to check the box. You cannot check the box. That is an option. They just won't give you the firearm.
Mm-hmm.
So there's no compelled to self-incriminate. And also, by that way, it's an opposite. Yeah. Incidentally, by the way, for the person who said, apparently in chat, who said, they wanted to talk to me privately. I'm not guaranteeing, incidentally, that I will necessarily be available at any particular time. So for the person who said, I want to chat with you on Discord, I'm not necessarily guaranteeing I'll be available tomorrow or any other particular time. So I am available now. If you want to talk now, you can talk now. If you don't want to talk in public, I respect your choice, but I may not be available at some other time. So this is an opportunity you have. If you don't want to use that opportunity, that's fine, but don't come crying to me if I'm not available when you want to talk. I made myself available. And so that's, if you don't want to take advantage of that opportunity, then fair enough, but that's it.
How about an Alien Enemies Act question?
Yeah, sure. I'm not necessarily going to be able to answer super intelligently, but I'll do my best.
I think I heard another attorney say that they may not have a lot of rights, the people who are arrested about to be detained, but they still always have a habeas right. Is that correct?
That's partially correct, yes. The habeas is just justify why I'm being detained. But that habeas right can be extremely, cursory. But that's exactly what's going on now, in part, is with that issue, because the DC Court of Appeals for the DC Circuit just came out with a decision 2-1 today that the injunction relating to the Alien Enemies Act for the moment is going to remain in place. And so,
but doesn't the habeas hearing have to be in the federal jurisdiction where they were detained?
I don't necessarily know the answer to that question. I don't know.
Well, aren't the two check boxes for that 14 and older, and then are you a part of the class, like the group that is to be detained or whatever?
I don't know the answer to that question either on the finer points. It would make sense to me that it could be brought in DC because that's where all the federal agencies are. And so if you're like complaining against the federal agencies, it certainly seem logical that you could bring it either like where you were arrested or in DC because that's where the agency is based. Seems logical.
Well, they're just forum shopping with the place, but
well, be that as it may,
the Supreme Court,
that as it may, that may be true, and the Congress can curtail that to some degree. This used to be a bigger problem in patent law until the Supreme Court kind of could have kibosh on it. It used to be the case that basically all the patent cases were filed in the Eastern District of Texas because they were super patent friendly for some reason. Who knows why, but they were. And like basically 100% of the time, they'd vote with the patent holder. So all the patent people filed there, and the Supreme Court kind of curtailed that a couple of years back to make it harder to venue shop in the patent law. But yeah, the Congress has the right to decide where the venue is. Except in the case of crimes. In the case of crimes, it has to be tried in the district and state in which the crime occurred. So if you're talking about a violation of a criminal statute, that has to be held in that place. But otherwise, I think Congress can pretty much define like where certain cases are held. For example, when they did the TikTok ban, as part of that, TikTok ban that Congress passed as part of the law, they said jurisdiction lies in the DC Court of Appeals, which then became the trial court. The trial court was the Court of Appeals because that's the way Congress wrote it. And it's like, we're picking one venue. They thought that through. There's like, we're not doing venue shopping. We're telling you exactly where it is. It's in the DC Court of Appeals. That is now the trial court. Congratulations, you have one choice. And that's what they did. That's where they filed. And so that Congress can do that kind of thing.
So you think a TRO can tell a president to turn a plane back around?
I don't know the answer to that. I have questions relating to injunctions broadly speaking, and this is a point I've raised multiple times. I have a question about federal judges because there are 94 districts in the United States, and some of those districts don't even cover their entire state. So I have a little bit of a question with, wait a second, why can one of 94 districts issue an injunction with potential nationwide impact and extraterritorial impact at that? Why can they do that? And the Supreme Court has allowed this issue to go on too long. This has been a thing like about 40 years, maybe 60 if you want to be generous. And it's definitely ramped up in particular since I'd say probably the Obama administration where it's really started to ramp up. But this issue is a bigger problem with what exactly is the jurisdictional boundaries of these district courts, because they're either making decisions, they're doing universal injunctions, which go beyond their jurisdiction, or they're, in that case, doing extraterritorial because the plane is no longer within the territory of the United States. It's like, can they do that? And the real problem is the Supreme Court has never clarified these points. And so one of these days, the Supreme Court's really just got to clarify exactly what the rule is. So I don't know what the answer to the question is because the Supreme Court won't tell me. And it's annoying.
Yeah, I completely agree with you, Kurt.
Well, isn't the solve for this problem already there? It has to be two of the branches to tell the other one it can't do that, right? Either through impeachment for either the judiciary or the executive, or the Congress kicks out whoever they do, or they don't get reelected, right? That's the backstop for all this stuff, right?
Well, I mean, sure, there's always checks and balances all over the place. That was the point of a lot of the structure of the Constitution. So, yeah. And, I don't necessarily have a problem with the judge interpreting federal law. I mean, that's one of the things they do with their time. But the scope of their power in terms of this is something that needs to be clarified. Would be nice. I mean, basically no one's told them they can't. This is like basically what happened is judges just kind of decided they could, and no one's told them they can't. And so they've just kind of been doing it because no one's told them no. And I don't necessarily know that the answer should be no. I don't know that it should be no. But it's like someone's just got to clarify exactly what the rule is. Because if the rule is, any one of these 94 judges can do this, then you have venue shopping problems. You have, you have potential conflicts between, which judge issues order. My judge says no. My judge says yes. Who wins, right? A judge in North Carolina says the plane needs to turn around. A judge in California says the plane doesn't. Who wins, right?
The fuel tank.
Yeah, the fuel tank wins. Yeah, I don't know, right? So like these questions remain unsolved. So someone just needs to define what the rules are, and then I'll be happy.
Well, then we won't have the federal circus of courts.
Well, could Trump sign an executive order telling his entire branch not to abide by TROs?
Well, I wouldn't recommend that because that's really setting up a constitutional crisis. Because you have the executive branch in defiance of an order of the court, and I have questions about the legitimacy of that order. But for the moment, the answer is they seem to be legitimate. And so I really don't want to do a Jackson. The reason I don't want Trump to do that is for the exact same reason I don't want President AOC to do it. Because I'm thinking ahead. I don't want President AOC to say, the Supreme Court has made their decision, now let them enforce it either.
Well, I'm not saying that he can defy what the Supreme Court says. It's just this lower court You know, because the lower entities in all three branches are always telling the other ones what they can and cannot do, like the lower level. But when it gets up to the top,
Right, but whatever the answer would be the same for President AOC. Is my point.
Yeah.
And I have no
Well, I don't
problem
know.
with that. That's why I'm like, this is why I'm like, I have a question and I don't know what the answer is, because it's like, okay, do I want, say, the Eastern District of Texas to issue an order on a TRO stopping President AOC from whatever batshit idea just went through her head? It's like I might want that someday. So, thinking ahead that I might want that someday, I'm like, maybe I need to think a little bit more critically about what exactly it is I'm asking for and exactly what I'm looking for, so that I don't wind up really sad when, the Eastern District of Texas is like, well, I can't do it anymore because they took away all my power. And now AOC, now it's only the Supreme Court who can stop AOC whenever they get around to it, right? So, I mean, every decision comes with consequences, and every decision comes with consequences for presidents I might not like. So I'm just trying to think ahead.
Can one district court vacate an order from a different district court?
See, these are good questions that really need answering, don't they? Yeah, I saw someone else joined. Hi, you're on with Uncivil Law. Who's this? Anybody? Didn't someone join? I thought I heard a join button. No? Okay, never mind.
I think it was somebody unmuting.
Okay, great. Yeah.
Oh, but by the way, Kurt, I like the VV in the background.
Oh, thank you. Yeah, I like it too. It's pleasing me right now with the display, so it's a little bit nicer than the Uncivil thing. So I'm pleasing me.
And I didn't get a response from you earlier. Do you want me to send that stuff to your PO box?
What stuff is that?
The invite for the party for my daughter.
Well, yeah, if you're going to send me a physical invitation, you can send it to my PO box, or you can just send me an email.
Okay, cool. Yeah, she's excited to be a Buccaneer next year.
Excellent. I'm glad she found something that worked for her. That's awesome.
Yep.
Speaking of the Clemson sign you got up there, I thought that was the rack of the horrible mistakes everybody's ever made.
Aww. That's not nice at all.
I mean, just look what's sitting right next to it. That evil thing.
Beefish, yeah. I had a great time at Clemson. It was a good experience. I would definitely go back again.
Yeah, let's just hope those wildfires don't go too close to the campus.
Yeah. Karen Reed asked the jury, as I'm just reading this article in the staff chat now from Kestrel from earlier this morning. Karen Reed adds juror from first round legal team. Holy shit. That's pretty funny. That is just hilarious news. Wow.
Right.
What a troll.
I'm going to have to get going because the wife just told me I woke her up.
Okay, well, thanks for dropping by. I've enjoyed our time together.
All right. Take care, Kurt.
Bye.
Later.
All right. Well, I guess unless anyone else is going to join our chat, I guess I'm going to go and wrap things up, because that's sort of where all the issues I want to talk about. I just wanted to talk about how I was frustrated that, it's like, oh, I disagree with Melanie, therefore I'm no longer going to subscribe to you, or you disagree with Trump, or you think that this ATF regulation at least is in the ballpark of something that might seem like approachable, and it's like, oh, and all this stuff. It's like, it's frustrating sometimes, because it's when I don't give the answer that people expect, then they get angry. And it's a little bit irritating for me, because it's like, well, I'm just trying to do what I always do. And it's like, sometimes the answer isn't what you want it to be. Doesn't necessarily mean I'm right, but I do my best, but whatever. But I do appreciate everyone who spent some time with me. This was a lot of fun, and I hope you had fun too. And that's all there is for now. Yeah, is Karen Reed smart to add the jury as a middle finger? It's pretty based. It's pretty based. It's pretty based. It's awesome. Yeah. You don't waver in my opinions? Well, I waver in my opinions to the extent that I find evidence to persuade me differently. I've definitely changed my opinions. Sometimes chat has changed my opinions. You know, when they've been more respectful and been more engaging and less trolly and less like being dicks. So even chat occasionally has changed my mind. So it's like I'm not necessarily opposed to changing my mind. I just try to express myself. And even on legal points, I sometimes change my mind because, you know, I read something and I'm like, oh, that's a better argument. You know, sometimes I read sometimes I'm like, I don't think this is true. And then I read something from a judge and I'm like, oh no, that's true. Right. So it's like, you know, you get, sometimes someone has a better way. Sometimes people have a better idea. You know, I've been doing this for 21 years, so that doesn't happen incredibly often, but, you know, it does happen every once in a while. It's like, oh, that is a better idea. But, you know, I just try to express myself clearly and try to express myself thoroughly and hopefully with logic and reason. And that's what you want to do, right? And just try to think it through. Am I covering Karen Reed? Of course I'll be covering Karen Reed. I'll be covering the case. And it'll be also very interesting. It'll be very interesting because I'm going to try as best as I can to go into the Karen Reed retrial with as blank a slate as I can manage to pull off. Now, this might be slightly more challenging because I know a lot, but I'm going to try to put that all aside and try to pretend like I don't know anything and try to assess the case based on what is actually presented in court, because of course, that's what the jury is going to do. And, you know, it's at least hypothetically possible. It's hypothetically possible that the prosecution is going to fix some of their many problems. And it's possible the defense is somehow going to fall flat on its face. And so, you know, there is a non-zero probability that there's a non-zero probability, although it's not particularly likely, but it's possible that at some point I'm going to say something like, the prosecution is winning this. I think that they're making their case. I think the prosecution is able to get to, you know, their beyond a reasonable doubt standard now. Or whatever, right? Like these are non-zero possibilities. So, or, you know, the witnesses will be more credible or whatever, right? The trial is going to be different. And so I think it's going to be really interesting if that happens. It's going to be really interesting if, you know, for whatever combination of flukes occur, you know, my opinion relating to the question of, can the state prove its case beyond a reasonable doubt, right? Because that's the question. Can the state prove its case beyond a reasonable doubt? If my opinion of that changes based on what happens in the room, and I say, hypothetically, oh, I think the prosecution's winning this, I think I'm going to get a lot of pushback. So I'm looking forward to that possibility because I imagine I'm going to be incredibly frustrated. It's like, weren't you free, Karen Reed? Didn't you say the state's case blows chunks? I did say all those things, yes. Didn't you say everything about the logs and the solo cups and leaf blowers? What happened to you, man? It's like, well, what happened to me is that there was another trial and those things didn't happen in the second trial, right? Those things didn't happen in the second trial. And so therefore they weren't part of the analysis anymore. And therefore the analysis changed. What happened to you, man? I thought you were pure, man. Right? So I'm already looking forward to the fights. I'm already having the fights in my head. That's how excited I am. I'm already having the fights about this hypothetical in the future in my own head. Chat is living in my head rent-free, basically, is what I'm telling you. It's exciting and fun. Can they legit close down or stop accessible Social Security? As a program completely? Maybe. Yeah, maybe. I mean, it would take an act of Congress and there's no goddamn way, but possibly. Yeah. So we'll see what's going to happen. All right, guys, I'm going to sign off for now. This has been an interesting and slightly infuriating chat at times. I've been Uncivil Law. Until later, my friends, I hope all is well. Cheers, my friends, for now, and goodbye.